The graphic, please be seated.
Veuillez vous asseoir.
The President, the court is now in session. Yesterday's proceeding was up to the points regarding the issues of the request of the parties, and the decisions need to be made by the trial chambers regarding those requests. Yesterday, the trial chamber was up to that point. However, due to the time limit for yesterday's session, and the request was not yet decided yesterday, and today we will discuss that issue again. Those requests regarding the following points. First, the trial chamber noticed the request by the civil party lawyers to present the factual agreements in public in this hearing, which were agreed upon by the co-prosecutors and the defense counsels. The trial chamber will direct the defense counsels, if they have concrete agreements on the facts, then the trial chamber will publish in public at the end of the sessions today on those factual agreements. Second, yesterday there was an attempt to put forward the request, and the trial chamber would bring up those requests in order to clarify on certain of them, and then the trial chamber will note all those requests in order for us to discuss and make decision. Next, the trial chamber will ask the parties whether they have any other additional requests. And I also would like to remind the defense counsels and the civil parties lawyers. For the civil parties, please follow your group order, group 1, 2, 3, and 4, etc. And when you stand up, before you speak, please announce your names and your group to the trial chamber, because the whole trial chamber does not know your names individually. I would like any party who wishes to raise your request or other issues to bring to the attention of the trial chamber so that we can make decision. Thank you.
Good morning, Mr. President. My name is Alain Werner. I'm a co-counsel for co-lawyers, Civil Parties Group 1. And I do have one request for guidance, Mr. President. Mr. President, on the 20th of March 2009, you issued a direction on the scheduling of the trial. And on point 9 of the direction, it was explained or clarified that the evidence will be divided into topics. And you did indicate 7 topics. And then it was further clarified that on each topic, first the accused will be questioned, and then relevant civil parties, and then witnesses, and then experts for each topic. Now, Your Honours, most of the civil parties that for our group will come before this court to talk do not have anything to say on any of those topics. And the reason is that most of them are relatives of people who were detained at S21. So they have nothing to say on M13, S21, Shonek, or the character of the accused. So we would be grateful if, Mr. President, you could clarify the matter for us and tell us when do you intend to call the civil parties. And it is important for us for that reason. We have, in particular, 2 civil parties, E286 and E287, 2 of our civil parties who will come in front of this court and who will hopefully address Your Honours. And they do not live in Cambodia. And as a matter of fact, they live quite far away. So, of course, they will need to have advance notice on when they have to come in front of this court. So we would be grateful for such clarification. Those are my submissions. I'm grateful, Your Honours.
Good morning, Mr. President. Good morning, Your Honours. My name is, or perhaps could you also clarify if I should present my name always if I stand up? And I think the chamber should know me. But I can, however, repeat it. My name is Silke Stuczynski. I'm a colleague for civil parties. I would like to make one request that is related to the amendment of the agenda, the scheduling that the chamber has sent. There we have the point of opening statements, and we were notified that the defense will make the opening statement. On Monday, we have learned that also the accused... no?
Speak louder.
Okay. On Monday, we have learned that also the accused wanted to make his opening statement, and he did so yesterday. I would like to make at this point a short introduction. Civil parties are parties to the proceedings. They have the right to participate. What is the meaning of participation? This means, of course, to be physically present. But that cannot be all. The right of participation includes, of course, the right to be heard. And civil parties who heard yesterday the statement of the accused, which was announced to be held only on Monday and then repeated yesterday orally, brought to the civil parties the wish to respond to the accused and to express their concerns and views. I think this is also for a court who emphasizes to bring justice to victims who are here exceptionally the first time in internationalized or international tribunals, parties to the proceedings, that they should be granted the right to respond, the right and the fundamental right also of fair trial to be heard. And I would like to draw your attention to the jurisprudence of the International Criminal Court. In the Lubanga case, the pre-trial Chamber 1 decided on 22nd of 2006 that victims who are only participants with less rights have the right to be heard, and at all stages, very important, at all stages of the proceedings, if their interests are concerned. They are only participants. They were granted the right, and the pre-trial Chamber 1 explained the right of participation means, before the International Criminal Court, means that victims as participants are allowed to make an opening statement and a closing statement. That was something that the pre-trial chamber expressed, how they understand the participation and what does it mean. Of course, the participation right cannot be limited to be physically present, and it is, of course, not enough to be heard at a later stage of the proceedings when the chamber intends to invite several civil parties, of course not all, and of course the right to participate must be granted and should be granted at every stage of the proceedings, and that means also at the first day when the accused personally addressed the court in his opening statement, and not only as normally scheduled to give comments on the charges like scheduled under point 8 of the agenda, but he made his own opening statement. And I would also like to draw your attention on the fact that bringing justice to victims means also that they could express their view on what do they think about the apologies that the accused expressed yesterday, and that they can express their view on the what he said, that he is a victim of the decay period of the leaders of the Khmer Rouge, and I think this should be in the interest of justice, given an opportunity to civil parties to respond, and or their lawyers to respond to the opening statement of the accused, and of course also in general. And so we request to be granted this right to respond to at least to the opening statement of the accused. This is different, not the same request that was submitted around 2 weeks ago, where we asked for to get the right to make an opening statement. Now this is an amended request to react and to respond and to perform, to respond to the accused and to perform our right to be heard. And so I ask the chamber respectfully to decide on this request. Thank you.
The civil party's lawyer. My name is Muchswanari. I'm in the civil party group 3. First, my respect to the President and the judges. I have another request, in addition to the request made by my group. I would like to request to the chamber for your instructions regarding the list of civil parties which the trial chamber intends to call them for the testimonies. And I would like to know the exact date that each civil party has to appear before the chamber. Thank you. My name is Kaing Guek Eav. I am from the civil party group 1. I would like the chamber to make an observation during the hearing. According to the scheduling for the participants, however, during our discussion, during the hearing, there is an objection, for example, and then there is a protest or objection, and then the judges have to retire for liberation. So it's not consistent with the scheduling already planned. Second, when the lawyers who make the objection, and to that objection, I would like the civil parties lawyers also to respond to that objection. Thank you.
I am Pierre-Olivier Su. I am a lawyer for Civil Party Group 4. Mr. President, Your Honours, I am in complete agreement with what my colleagues have said with regard to the scheduling. We would like to be able to assist our clients appropriately during the hearings. This goes to equality of arms between the defense and the civil parties in particular, following the opening statement that was made yesterday by the accused. Thank you.
The President, is there any additional request? If there is no additional request, the trial chamber would like to ask the defense counsel on the agreements on facts which was mentioned yesterday. So that agreement on facts with the co-prosecutors, do you agree on these particular facts? And if you do, can they during the hearing in summary? However, it is not to be done now. It will be toward the end of today's session, so that you have adequate time to prepare for the agreements on facts.
Mr. Ho. Thank you, Mr. President. Good morning, Mr. President, Your Honors. We filed to the Chamber yesterday the agreement on the facts which we worked on with the co-prosecutors and the accused, and the document that we filed yesterday can in fact be made public. The Chamber has been in possession of this document since yesterday evening after the hearing.
The President, please, Judge Lavange.
Judge Lavange, just to clear up our position, we would like a summary to be presented publicly at the hearing so that the parties and the public can be in the know, and we wish to find out whether you could prepare such a summary before the end of the day's proceedings. Mr. Ho, as my learned friend of the prosecution said yesterday, if we provide such a summary, we should have to read it out for at least 2 hours. I think it might be a little hard to follow, but if the Chamber considers that this is necessary for the public nature of proceedings, we will do so. But I must say that it will necessarily follow the format of the document sent initially by the co-prosecutors. After each paragraph, we will be forced to indicate whether we agree, whether we do not agree, whether we agree in part, whether we do not contest the fact, and I'm afraid this will take a lot of time. But if the Chamber so wishes, we are ready to do so. It will not be a summary as such.
The President, please, the co-prosecutor.
Thank you, Mr. President, Your Honors. Good morning. Indeed, I second the comment. I will, of course, abide by your order, but I don't think it is possible, nor would it be very helpful, at least on the public side, and possibly not that much helpful on the trial chamber side, to have some kind of summary made. As we've said, for example, one of the paragraphs of the closing order on which this agreement of fact is based, and as you were able to see from the documents we sent to you, each of these paragraphs, or a lot of these paragraphs, were subdivided into specific facts that we thought, and obviously the defense concurred because they answered to those specific facts, that we thought an agreement on those specific facts was useful or would be useful to the chamber. I now realize that perhaps for the sake of efficient use of the court's time, we may not have been that helpful yesterday to you by suggesting that we simply file into the case file that agreement of facts, which I note again, we forwarded to the defense in January of this year, received the French agreement 2 weeks ago, I believe, and the Khmer version Thursday. So, it says that all the best intentions, etc., etc. Obviously, we are there to assist the chamber, and if the chamber feels that it would be best assisted and the record would better reflect, we can indeed read these facts that have been agreed to. It would take probably, I would estimate, about 2 hours of the court's time. It would certainly clarify for all what the defense position is on each specific relevant facts. At least we submit they are relevant. And if that is indeed the wish of the court, we will of course abide by it, either the defense or us. And again, I apologize if our procedure was not as helpful as it could have been.
។
The President, the trial chamber would like to ask the civil parties lawyers regarding the agreement on the facts between the co-prosecutors and the defense counsel. Do the civil party lawyers have any comments regarding this agreement on the facts? Do you have listened to an attempt to show the public the factual agreements? However, the co-prosecutors and the defense counsels have their own reasons in presentation of the agreement, and I would like to seek comments from the lawyers of this Group 1, if you have any comments regarding this issue. Thank you.
Your Honours, I'm grateful. Thank you for your request. We have not seen the agreed fact, obviously, and if your question pertains to whether or not we would like this fact to be read out, where concerning our group, we are in your hands. We are indifferent. We are in your hands. I'm grateful, Your Honours.
The President, the lawyers for Group 2, please.
Okay. Your Honours, we have not yet, as my colleague said, received the agreed facts, but for the how to proceed with this, we think it is really time-consuming to read it out in public, and which is repetition, of course, of the indictment that we have heard before yesterday. And we suggest to, if it is filed, to put it on the case file, of course, but not to read it out. And also a summary, from my point of view, does not make sense to summarize these points. That is, I would say, impossible. It should be, if it is made public, then it should be read out. But we prefer that it is attached and put on the case file. Thank you.
The President, please, the lawyers for Group 3.
Thank you, Your Honour. Well, I would like to repeat the request that I presented yesterday, and I feel that there's a bit of reticence here concerning the participants. I think that indeed it would take about 2 hours, but I think that 2 hours is rather a small amount of time in relation to the duration of the hearings that has been scheduled. But I think that it is extremely important, after having heard on the part of heard Duch's confessions, heard his regrets, that we specify in the facts that are incriminated, what is indeed from the start of this file as being accepted, as well as the points that are contested. Because even if he's accepting many, many things, if we list there are certain points that are contested, I think it's very, very important so that we can make this immediately public in relation to our civil parties as well as in relation to the public following these hearings. I think that it's very, very important that in the indictment, the material facts that have been brought up by your competence, we should present the facts that are accepted, because I think it's very, very important, because this point is going to concentrate the elements on which there is a disagreement, but this point is also immediately going to shed light on the seriousness and the reality of the facts that are accepted. And I think that this is an essential point, to know as of the start what is accepted and to know the points that might be contested. And despite everything, when we take the trouble of following these points, we notice that maybe the points that are contested remain important. but however are minor in relation to the points that are accepted. And I think it's an important point that as of the start, that what is no longer contested in relation to these very grave facts, well, that these points are recognized, acknowledged, and that we take points. Because, on the contrary, in the part, and I think that this could lead to difficulty if there's a difference in the acceptance of points between the public and the chamber. Petition out of principle that acknowledges the facts and that he regrets these facts, globally speaking. And I think that if this element is extremely important, in detail, the document that relates very exactly each one of the points, I think it would be only necessary to include this document in the case file so that we can go directly into the examination phase, that is to say, in the substance of these proceedings.
Mr. President, the lawyer for Group 4, the lawyer for the Civil Party Group 4, please. The floor is yours. Oh, you already spoken. It's okay then. Please, the counsel for the defense.
Your Honor, I am aware of what Maître Martin Jacquin is presenting to us. Maybe is to make things more clear. Maybe we could do this in two different ways. That is to say that the prosecutor would read the paragraphs that he proposed to us, and at the end of each paragraph, the defense will rise to say, we agree, or to specify the comments that the accused wanted to provide. And it will be then more dynamic, let's say. I would say it would be a more dynamic presentation. We could say, and indeed, this would address the concerns that were presented by Maître Jacquin, and which I perfectly understand. This is my proposal, if, of course, my colleagues from the prosecution side agree.
I think sometimes the more we speak, the more complicated things get. As I said earlier, most of the facts are agreed to and will hopefully help this chamber. Some of them, some of the key ones, are not agreed to by us or by the defense. And the accused himself, as far as I understand the procedure that was taken, has himself commented on some of those specific facts. Now, obviously, the defense can file any documents it wish with whatever comments, and it will be debated if there is to be a debate. However, I fear that if we were to read into the record today or at any other time written comments by the accused, we will get that debate. In other words, I fear that if the accused, through this means, would be to, in essence, testify about some of the facts, it will lead to, perhaps, debates, which we will have at the relevant times in those proceedings when the accused makes his position known on some of those specific facts. I would suggest, although as I'm sure well-intentioned the request or the suggestion is from my learned friend, that perhaps, if only for the sake of serenity, at this stage, we do read into the record what is agreed without comments. We could indeed read the proposal either singly or by subject or in bunch, after which the defense would make their position known. I suggest that then the record would be quite clear about what is agreed to, and the rest will be left for its proper time and proper form during the substantive part of this trial, or the next substantive part of this trial. I suggest personally that this is probably the best way to achieve what I think is now developing as a consensus on this issue. Thank you.
The President, please, the Defense Counsel.
I agree so that we only present the paragraphs on which the accused has said that he agrees or that he does not contest. I agree with that, yes. But we will therefore not read the paragraphs on which the accused interpreter has provided comments. We will just focus on the paragraphs on which the accused said that he agrees or which he says that he does not contest.
The President, now the bench has to retire to deliberate, and it is also a break time, so the chamber will take a break for half an hour for our deliberation.
Kaing Guek Eav.
Graffier, please be seated. The President, the trial chamber will now resume. First, the chamber would make an announcement to the co-prosecutors and the defense counsels and all the involved parties. The trial chamber decides the co-prosecutors and the defense counsels to read the agreement on the facts and the facts that are not disputed. And for some other issues, we will address them later. However, for the reading of the agreement on the facts, it will be done in this afternoon. So, please, the co-prosecutors and the defense counsels are prepared for the reading this afternoon. For our next proceeding, the chamber would like to ask the defense counsel, Mr. Kasavut, that yesterday you made a statement in response to the charges made by the co-prosecutors regarding the legality of the charges against your client. It is unclear whether what you raised is a request to the chamber to resolve that particular issue before the proceedings, or it is just to bring to our attention during this part of the proceedings as a response to the co-prosecutors. If it is a clear request to the chamber, we would like the councils to point to the facts or to relevant issues regarding to your request. So the floor is yours, Mr. Kasavut.
Mr. Kasavut, I'm grateful to your honors. What I have already stated in my statement yesterday, I began with that I as a lawyer would like to give some observations to the whole court to consider my following comments. I think those arguments are just the comments for the consideration of the court. Number two, when the co-prosecutors asked whether I challenge the jurisdiction, I am not intending to challenge it because I am quite aware already, and I could have raised it in the initial hearing already if I wished to do so. So what I raised was not to challenge the jurisdiction. I only wanted the court to follow the Rule 98, Rule 7 regarding the jurisdiction of the court over my client, because if he is not the most senior person or most responsible person to be prosecuted, then he should not be prosecuted. I just want to confirm that position, and I think they are just my comments for the court consideration. For example, I said that the co-prosecutors said that my client has something to do with the crimes against humanity because there had been some kind of armed conflicts and fightings between the Vietnam. And I would like to ask why my client was charged of crimes against humanity while Vietnam is not charged so on behalf of my client, I only ask for justice for my client. It's not to challenge the jurisdiction of the court. And regarding other points I raised, I asked that Cambodian sovereignty was not well respected, and I quoted Article 31 of the Cambodian Constitution that every citizen, every Cambodian citizen is equal before the law. And I ask, how can you say it is equal now, because many people are not charged while my client is charged. So I'm afraid that this is a violation to the Cambodian Constitution. And the reason I explained to the court, and I at this time would also make a request to the co-prosecutor to list down all the names, those people who are most responsible and senior people for democratic Cambodia. How many are they, and bring them all to be prosecuted, and or otherwise the court shall issue a decision or judgment to extinguish criminal actions. So I want the court to also consider this to issue such a judgment to make sure that justice is done for all the dead people and people who survive. But finally, I do not intend to challenge the jurisdiction.
The President, for our next proceeding, the defense counsels and the accused raised an attempt to issue related to the provisional detention of their client. The trial chamber would like to ask the defense counsel at this stage if you insist on raising such issue, and if so, what is your request to the trial chamber regarding this particular issue?
Thank you, Your Honor. The defense had indeed informed the chamber as of the preliminary hearing that it would bring up the question of detention. Can I call it provisional detention still, however? A detention that has been going on for 10 years is no longer provisional detention. And that is the question that I wish indeed to expand on before you, if you give me the permission, Your Honor. As we have reminded,
the President, please, the lawyer. The President, the floor is yours for the counsel.
Merci, Monsieur le Président.
Your Honor. As we have reminded initially, our client was arrested on the 10th of May 1999, and he was then arrested by the authorities of the Kingdom of Cambodia, and he was transferred before the military tribunal. And he remained before this tribunal during all of these years, up until the 30th of July 2007, when the co-investigating judges of the ECCC presented an arrest warrant against Mr. Kaing Guek Eav, aka Duch, and he was that very same day transferred from the detention center of the military tribunal to the prison here at the ECCC. And we have immediately requested that he be released, and given the amount of time that he had spent since his arrest. And we reminded that according to Cambodian law, but also according to international law, it was not possible to maintain someone in detention for such a long time. The investigating judges presented an order, and if I can sum it up, or summarize it, they stated that there is a problem, but it is not our problem, however. It is the problem of the Cambodian authorities. And we then appealed before the pretrial chamber. And in their review, the co-prosecutors, if I can summarize things again, stated that there is indeed a problem, but it is not our problem. And the pretrial chamber presented a decision in which they stated, and I will summarize it, we have no problems, and you will submit this question to the trial chamber. And we are before the trial chamber now. So, we, of course, are aware of the difficulty, including in relation to the civil parties. How can we imagine when the accused acknowledges, when he expresses his remorse, when he asks for forgiveness, how can we imagine that at the same time he can ask for his release? Well, simply because we have the most heartfelt respect for this chamber and for the ECCC, are therefore requesting here to state law, nothing else, just to state law. Even if it is a decision that is hard, that would be difficult to understand by the public opinion and by the victims as well, is the first decision that your chamber should render. Isn't it precisely a decision that should recall law? What does the law state? First of all, the Cambodian law, we have reminded, we have recalled the Constitution of the Kingdom of Cambodia from the Constitution of 1993, and the Criminal Code of the Duch from 1992, and the law concerning the duration of provisional detention from the 26th of August 1989. And in virtue of all of these, by virtue of all of these texts, it was provided, and in particular by virtue of the law of August 1999 and of its first article, it was provided that provisional detention of individuals accused of genocide, war crimes, or crimes against humanity would not exceed 3 years. That is to say that as of February 2002, Duch should have been released. Or, to say things in other terms, since February 2002, there is no legal foundation. I repeat, there is no legal basis for his provisional detention. So there was, however, renewals that were presented by the military tribunal in a rather incomprehensible way. And I remember of the very heated debate before the pretrial chamber, the debate between Madame Shileng and my friend Maître Karsavut, Council Karsavut. Madame Shileng explained that we have to maintain Duch keep him free for reasons of for public reasons, because we are afraid we fear for his safety, we fear for the safety of the victims, so we should maintain him in the detention. And Maître Karsavut answered, well, Your Honor, I agree with you. You are entitled to be afraid. For 1 year, yes. For 1 year, yes. But you are entitled to be afraid for 2 years. Do you remember? You are entitled to be afraid for the 3rd year as well. But after 3 years and 1 day, you no longer have the possibility of being afraid, because the Cambodian constitution stated that after 3 years and 1 day, you must release him.
I would like to add that during the proceedings before the pre-trial chamber, the President, in regard to the issue of detention, had invited a number of non-governmental organizations to file amicus curiae briefs. 6 amicus curiae briefs were filed. You will find them in the case file. If I remember correctly, 4 of the 6 non-governmental organizations supported the defense position. According to the law, due to justice and following the image and example that these extraordinary chambers should offer to all justice systems in the world, including the Cambodian justice system. How can NGOs come to support us before national courts if the extraordinary chambers themselves were to agree to irregular detention? So we ask you to take a difficult decision. We admit it is difficult, but it is the only possible one to take. We come before you to request that you put an end to the detention of Duch, because it is well beyond the acceptable time limits set by Cambodian law. And we have also exceeded the time limits provided for in international legal instruments. We referred to Articles 9 and 14 of the New York Covenant on Civil and Political Rights, and we recalled that in accordance with these articles, it is not possible to extend provisional detention for so long. Permit me to shed light using jurisprudence on the Articles 9 and 14 of the Covenant on Civil and Political Rights. I shall refer first to the jurisprudence of the European Court of Human Rights, that is Article 5 of the European Human Rights Convention, which on several occasions has found that countries, including mine, I must add, and very often Italy, has found them guilty of unduly extending provisional detention. And this provisional detention that I referred to has nothing in common with what Duch has suffered. We are approaching 10 years of provisional detention. Can this be imagined? And it is of particular interest, in my view, that I bring to the attention of the Court the jurisprudence of the United Nations Human Rights Commission, or more precisely, the Working Group on Provisional Detention of the United Nations in this regard. On the 30th of November 2007, it issued, that is this group, an opinion on deprivation of liberty for 8 persons arrested in Lebanon following the assassination of the former Lebanese Prime Minister Rafik Hariri on the 14th of February 2005. You might find it worth knowing that the Special Tribunal for Lebanon, jointly established by the government of Lebanon and the United Nations, as it begins to do its work, this tribunal is facing the same problem that we have before you here today. The International Commission of Inquiry had recommended the detention of these 8 people to the Lebanese investigating judges. And the Lebanese investigating judges did in fact decide to place these 8 persons in detention. The Working Group on Provisional Detention, that is the United Nations Working Group, issued an opinion which indicated that it was not possible to continue keeping these people in detention and characterized the detention as arbitrary. As the Special Tribunal for Lebanon begins its proceedings, this matter will be brought before it, and it will have to render a decision in the near future on this issue with regard to 4 of these people, as the remaining 4 were released by the Lebanese investigating judges. So what are you going to do, Your Honors? We have passed out. We have shared the decision which was rendered in our case by the military investigating judge on the 21st of July 2008. We requested this decision because we asked the military judge what his position was in regard to the Duch case file, Duch, who had been brought before him. And the military investigating judge said, considering that the prosecution of the case of Mr. Kaing Guek Eav, alias Duch, of the military tribunal, because at the time there was no law on the establishment of the ECCC, considering, I beg your pardon, Mr. Petit interrupts. Mr. Hu, I thought it had already been done. I'm sorry.
Vous avez version Khmer et version française.
You have the Khmer and the French version. Mr. Hu continues. Considering that after the establishment of the ECCC, the jurisdiction of the ECCC covers crimes against humanity and grave violations of the Geneva Convention of 12 August 1949, committed during the period from 17th of April 1975 to the 6th of January 1979. The military tribunal no longer has jurisdiction over crimes falling within the jurisdiction of the ECCC. Considering that the charged person, Mr. Kaing Guek Eav, alias Duch, has been prosecuted or is being prosecuted by the ECCC with effect from the 30th of July 2007, decide to put to an end or to bring to an end the jurisdiction of the military tribunal with regard to case number 397 of the 6th of March 1999, under which the charged person, Kaing Guek Eav, alias Duch, was questioned with regard to crimes provided for in the law establishing the ECCC. Phnom Penh, 21st of July 2008, the investigating judge. Following this decision of the military judge, which notes that he has lost jurisdiction in favor of the chambers, you are the continuation of the proceedings instituted against Duch, and this is clearly indicated in the first paragraph of this decision. Previously, the case fell within the jurisdiction of the military court because there was no law on the establishment of the ECCC. So there is a thread of continuity running through the case. You can no longer say, this is not our problem. I am sorry to bring this before you. It is now your problem, and you cannot avoid it. So what do we do now? First, I think we should rely on jurisprudence. And in this regard, I can think of no better jurisprudence or precedent than what transpired in the Barayaguiza, and I apologize to the interpreters, says Mr. Hu, which I shall spell, which is Bararawagwiza. Barayaguiza Jean Bosco. So, what was the issue at stake? The defense submitted that Mr. Barayaguiza, of whom it was commonly said that he was one of the main perpetrators or persons responsible for the Rwandan genocide, that his rights were violated or breached during his arrest, and he was kept in detention in violation of these rights. I now turn to paragraph 106 of the judgment of the 3rd of November 1999 by the Appeals Chamber of the International Criminal Tribunal for Rwanda and the former Yugoslavia, in which the Appeals Chamber said, the crimes charged against the accused are very serious. This notwithstanding, in the case in point, his fundamental rights have been violated on several occasions. There was a small paragraph for the prosecutor which is not relevant to the prosecutor here, but the chamber in the Barayaguiza said, and this is undoubtedly worse, the following: it would seem that the actions or the failure to act on the part of the prosecutor in that case amounts to negligence. But of course, this would not be true for our co-prosecutors in this instance. And in order to come to this determination, the Appeals Chamber of the ICTR concluded with the two paragraphs that I shall read out to you. In the instant case, we appreciate the power of words spoken by Judge Brandeis of the United States Supreme Court. We quote, decency, security, and freedom require that representatives of the state are subject to the same rules of conduct as ordinary citizens. In a state where the rule of law prevails, the existence of the state is jeopardized if the state itself fails scrupulously to comply with the provisions of the law. The state is the powerful and omnipotent institutor of force for good or evil. It teaches the people by example. Criminal conduct is contagious. A state that breaks the law encourages contempt for the law. It therefore invites each citizen to make his or her own law and encourages anarchy. To say that for the administration of criminal justice, the end justifies the means, criminal would lead to a terrible boomerang effect. As Judge Brandeis said, the court must take a firm stand against this pernicious theory. End of quote. And having quoted Judge Brandeis, the chamber ended its judgment. Thus, the court, and here we make reference to the International Criminal Tribunal for Rwanda, is an institution whose primary goal is to ensure that justice should be done, should not endorse such violations, and I refer to the violations I mentioned earlier. That is, it should allow that the appellant should be tried on the basis of charges of which he was accused too late would be a travesty of justice. Nothing less than the integrity of the tribunal is at stake. If the public were to lose confidence in this tribunal as the custodian of the human rights of every individual, including those accused of unimaginable crimes, would be one of the most adverse consequences, and it would be wrong to allow the accused, the appellant, to be tried in spite of such breaches. Although it is difficult for some to accept such a finding, it is the role of an independent justice system to end these proceedings so that other injustices may not arise. Mr. President, Your Honors, this decision or this judgment honors the international justice system. I can imagine in what state of mind the judges who rendered this decision might have been. They were presided over by Judge Gabriel Kirk MacDonald. I can only imagine. The chamber had gone very far because it ordered the immediate cessation of proceedings, and it prohibited the prosecutor from resuming the proceedings. I can assure you that we have not yet come to that. And I must be exhaustive, and I should add, therefore, that in the wake of this decision, the prosecutor, Ms. Carla Del Ponte, who had just been appointed international prosecutor, applied for a review of this judgment, and in a famous statement during a hearing, she said to the appeals chamber judges, if you were to uphold this decision, we can stop the proceedings. It was not a very legal thing to say, but it is true that the appeals chamber did review the decision, and the second decision it took was interesting too. And the appeals chamber said Yes, there was a breach of the rights of the accused. That is true. But we cannot ask that proceedings be brought to an end. However, we do say that after these proceedings, if the accused were to be found guilty, there would be a reduction of the sentence. And that is what happened. Mr. Baraya Guiza was found guilty. He was sentenced to life imprisonment, I believe, and his sentence was reduced to 35 years to take account of the breach or violation of his rights. So what do we ask of you today? Primarily, to bring immediately to an end the detention of Duch for the duration of the trial. And I emphasize, for the duration of the trial. And so, following on from what Mr. Kasavut said yesterday, we would re-establish the balance for the duration of the proceedings between what the co-prosecutors now refuse to prosecute, for those that the co-prosecutors refuse to prosecute for even more serious crimes, and Duch on the other side. These people are free today. Their names are mentioned in the press. They are not prosecuted. So be it. So that it would not be out of the question, therefore, for your chamber to say, well, for the duration of the proceedings, at least, whatever the charges for unimaginable crimes pending, we should free Duch for the duration of the trial. The defense would not challenge. The defense would not challenge the conditionalities imposed on this release. Why not decide, for instance, that Duch would be in a safe house, as has been allowed in other courts? And in this regard, Mr. President, Your Honors, permit me to make a common sense observation. Duch is a co-detainee with people who will be mentioned in the course of these proceedings. Do you not think that it would be preferable for all concerned if he were not detained at the same time as these people? So let us face facts. Let us be pragmatic. Let us apply the law. But let us allow what Duch has said, or let us allow Duch to be free to speak in the course of the proceedings. So, release, yes, but with conditions that you will decide, and justice will have been done.
Tout à fait subsidiairement.
As a side point, if you believe that for such and such a reason,
Le mettre en liberté.
The defense is requesting from you to say as of now two things. On the one hand, that in the case of sentencing, that the time spent in detention since May 1999 should be taken into account and subtracted from the sentence. And on the other hand, that he will be entitled to a reduction of the sentence to compensate for the violation of his rights, and going and restating the second decision of the appeal chamber in the Barayaguiza case. This is, I believe, with the totality of these possibilities, the solutions that are presented to you, in order to settle on this difficult issue. May I please say a last word to the civil parties? Nothing has been done against your rights. Everything is done for law. And I can imagine very easily that even as civil parties, you will only be able to second this position. I consider that the civil parties can only intervene in a hearing about detention if and only if they can provide the evidence that the release would damage their rights. The rest does not concern them. I cannot imagine one single moment, on one hand, that the release of Duch in a safe house would hinder the rights of the be detrimental to the rights of the civil parties. I cannot imagine that, whereas we are here to seek law, that anyone can oppose himself to the application above all of law. Law, Cambodian law, that states that any person can not be maintained in detention for more than 3 years. International law that prohibits arbitrary detention. Thank you.
The President, the trial chamber would ask the co-prosecutors if they wish to respond to the defense counsels regarding his presentation and the reasons concerning that issue. the issue of the detention of the accused and other issues which have been raised by Principal Ru. If you have, please comment. Thank you. Thank you, the President, Your Honors. What has been requested by the Defense Counsel for the release of the accused, we, the co-prosecutors, also have seen the Article 82 of the accused right of the rights to make such a request. The co-prosecutors wish to state that this is not a new issue. The request for the release on bail has been raised by the defense counsels since during the investigative phase. Therefore, the co-prosecutors consider this request has been rejected by the co-investigating judges. At the same time, there was an appeal to the pre-trial chamber, and the decision of the co-investigating judges, and the pre-trial chamber made a decision to uphold the provisional detention of the accused. That is the historical backgrounds regarding the request raised by the defense counsel of the accused. We, the co-prosecutors, still maintain our positions to request to the pre-trial chamber to continue the detention of this accused with certain reasons as following. 1. The co-prosecutors consider that Rule 63.3 of the internal rules, until this time, it is still a necessity, because this rule stipulates that if it is to be believed that the accused has been committed the crimes, and at this time the accused himself acknowledges the crimes occurred at S21 in the name as the chairman of that S21. So he acknowledges his responsibility at that office. 2. The co-prosecutors consider that in regards to the request of the detention of the accused at the military court from the 10th of May 1999, we would like to ask whether we, the extraordinary chambers in the courts of Cambodia, has to be responsible for that detention. The co-prosecutors would like to submit that the ECCC is an institution which is independent, separate from the military court, and this chamber has not been in function or in operations in relations to or in agreement with the military court, which is a local court. And these extraordinary chambers in the courts of Cambodia has never requested to the military court to make such detention. Therefore, these extraordinary chambers in the courts of Cambodia is a hybrid tribunal. And these extraordinary chambers in the courts of Cambodia is also an independent institution separate from the national courts or the military court which detained the accused in the past. The extraordinary chambers in the courts of Cambodia, with its independent, is again separate from the military court. These extraordinary chambers in the courts of Cambodia is an internationalized court. And I would like to raise the specific features of these extraordinary chambers. These extraordinary chambers in the courts of Cambodia was established with the agreement between the royal government of Cambodia and the United Nations to create a special law with its own responsibility from its establishment. These extraordinary chambers in the courts of Cambodia is not bound to judge on the appeal of the National Court, and the detention raised by the Defense Council involves the National Court. Therefore, the co-prosecutors consider that if the Defense Councils at the International Court consider that their client's detention, the competency of the court or of the appeal court falls within the local appeals court. So we, the co-prosecutors, know that Mr. Kasavot, who has been the defense lawyer for this accused, has the right to make an appeal to the National Court. But his relinquishment of such right is his own responsibility. These extraordinary chambers, in agreement, does not have any agreement with the military court. And the military court also stated the law on the establishment of the ECCC for the charges of the accused. However, I would like to submit that we need to consider the proper proceedings within the chambers, considering the functioning of the office of the co-prosecutors, as well as the functioning of the office of the co-investigating judges. These two offices have their own separate independent duties, and these two offices, which composed of both national and international staff, national and international prosecutors, and national and international investigating judges. So our unique feature is separate from the National Court. Even if you look at the appointment of the judges, they consist of both national and international judges, and they are not related to the National Court. The National Court, this chamber is not responsible for the functioning of the local court or the military court. So the violation of the accused's right by the National Court is not the jurisdiction or the responsibility of the chambers. So Duch detention at the military court cannot be taken into account, and for this chamber to make a decision on such issue. Point number 3 that I would like to raise regarding the continuation of the provisional detention is that what the pretrial chamber has decided to uphold the order of the investigating judges and to continue the provisional detention of the accused. We have observed that since that decision of the pretrial chamber until today, we have not seen any changes in circumstances besides the decision of that pretrial chamber. Therefore, even if Article 82.3, which allows the Defense Counsel to raise such a request, that is his right, either verbally or in writing. However, it needs to be considered that whether the circumstances have changed during the rejection of the appeal or any new circumstances arrived that needs to be considered in order to release him on bail. Point number 4. The co-prosecutors still maintained the provisional detention at this time is necessary to ensure by law, as stipulated in Article 35 on the law on the establishment of the ECCC, which clearly stipulates the prosecution of the accused is only before the trial chamber. Therefore, our submission and the continuation of the provisional detention is to avoid the trial in absentia of the accused. And in order to ensure that, we need the trial chamber to continue the provisional detention to ensure his trial in person. Number 5, in order to ensure the safety and the security of the accused. Duch, until this time, the public, who are the families, members of the victims as the victims themselves, know Duch clearly. Therefore, if the trial chamber releases him on bail, it's going to be an issue which is a risk, and the victims or the victims' families who are angry because their family members suffered or lost their lives during the democratic Cambodia, that would make them angry and take revenge on him. This is an issue on his own safety and security. Moreover, if such revenge occurred on the accused, it will also have an impact on the public order if there is such an attack on the accused. Another point that I would like to raise is in response to the order raised by the defense counsels. It's the order by the military court on the detention. My observation is that it clearly states the military court relinquishes its jurisdiction. So, after the ECCC has been established with its jurisdiction, it means the military court relinquishes its jurisdiction after the establishment of the ECCC, which was in 2006. And the military court already relinquished its jurisdiction after the establishment of the ECCC. So this is clearly stated, and in this order, there is a signature dated the 21st of July 2008. So this decision on the detention, on the relinquishment of the jurisdiction is appropriate, and the co-prosecutors agreed upon the content of the order made by the military court. Because of these above reasons, the co-prosecutors still maintained our positions to seek permission from the trial chamber to continue the provisional detention of this accused. And the last point raised by the defense counsel regarding the deductions of the sentence, etc., and etc., is the discretion of the trial chamber. Thank you.
Monsieur le Président, je vois les partis.
Mr. President, says Mr. Hu, I see the civil parties are on their feet. I'd just like to recall the law. The defense's request to make presentation is within the ambit of Rule 82, in particular paragraph 2, which says at any time the chamber can order the release of an accused on the bail if necessary, or order the accused detention in accordance with these internal rules. The chamber shall so decide after hearing the co-prosecutors, the accused, and his or her lawyers. As I said, the civil parties do not have a role to play in such a discussion.
Civil Parties Group 1, we are aware of Rule 82, paragraph 3. However, because it is such a fundamental issue for the civil parties, we would request, Mr. President, to use your discretion to allow at least a few minutes for the lawyers for civil parties to address this court.
Please, lawyer group 1, you take the floor first. Say the president. The president, could the lawyers please wait a moment? We need to discuss a little bit. The president. The civil party lawyer, what would you wish to state at this moment?
Your Honor, we would like to address the Chamber a few minutes about the legality. And a lot has been said about the legality of this request, and we would like to have the opportunity, a few minutes, to address the Chamber on the legality of this request. Did you get what I said? Thank you, Your Honor.
parle tous là-dessus.
President. Just now, the civil party lawyer tried to make some observation concerning the legality, but this legality matter has been raised by the defense counsel, but latest matter here is about the comments made by the defense counsel concerning the release on bail of their client, so that his client can be kept in a more separate secured building. And in Rule 82.2 and Rule subparagraph 3 of the same rule, in the decision to decide on the matter, the trial chamber lists or hear only the defense counsel, the accused, and the co-prosecutors, and that the trial chamber will not listen to the civil parties. So we will make sure that sub-rule number 2 and sub-rule 3 of Rule 82 are genuinely abided. So the trial chamber who will speak first, says the President. What are the other issues you would like to raise?
Could I request, or could we request to reconsider your decision that you have taken and recall the decision from 20th of March 2008 of the pretrial chamber? This decision was on civil parties' rights concerning the question if civil parties are allowed to participate, and not only physically, but to participate in detention appeal hearings. And this pretrial chamber decisions outlined the extent of civil party participation. And I would like to recall that, of course, this court should also be consistent, even if this decision, fundamental decision on civil parties' rights, was taken by the pretrial chamber in the case against Nguyen Chia. And I would like to let you know the pretrial chamber, or what the reasons were why the pretrial chamber decided that civil parties and their interests are concerned if the accused appeals the detention order, and if it is pending, if maybe the accused could be released. The pretrial chamber stated that civil parties' rights, and namely the right to reparation and to seek reparations, could be affected, and therefore civil parties should perform their rights before, and this is only an example, of course, but before the pretrial chamber during the hearing. That means also we were allowed and could submit written pleadings and to give short oral observations in the hearing itself. And we have here, if I compare the situation in the pretrial phase with the request now of the defense asking for the release of the accused, which is comparable from the content, even if we are now at the trial stage, with the situation when the defense or the accused, the charged person, appealed the detention order, or are appealing now in case 2 the extension of the detention order. And I think the trial chamber should reconsider its decision according to Rule 82 and to take into account that, of course, only the reason that civil parties or civil party lawyers, co-lawyers, are not mentioned in Rule 82, 2 and 3 does not mean automatically, if you have a look on the idea and the spirit of civil party participation, and to look first, we are parties and not anybody or nothing. Secondly, civil parties are directly concerned with possible or the decision that the chamber may take upon the request of the defense. And of course, therefore, civil parties have, or their views and concerns have to be taken into account. And again, the fundamental, or one of the fundamental rights of participation is the right to be heard. And this is something, and moreover, if it is a matter that concerns civil parties directly, so that I please the chamber to reconsider its decision from today to reject that civil parties could take a position, or again to review and have a consistent jurisprudence within this court and in the whole of this court, even if not you have taken this decision from, which I mentioned, the fundamental decision from 20th of March 2008. But I think for civil parties it is the same matter that is concerned, and so of course the trial chamber should not take another position and excluding with a formal argument civil parties are not mentioned in Rule 82, 2 and 3, and this is a formal argument, but
the President, the trial chamber already note the request, and I think it will take the whole day to hear that argument. The trial chamber will take this matter to be considered at within the day. Would you like to add any further or make any further comments?
I do not know, sorry, I do not know when the mic was cut off and what was possible to be translated, because I didn't see it, and therefore I would like to get guidance.
The President, now the trial chamber would like to inform you that the chamber will take your request to be considered during lunch break, and after the break then we will make a decision on the rights of the civil parties in regard to the request, the argument made by the defense counsel for the release on bail of their client, and also we need to discuss the matter in conjunction with the existing sub-rule 2.3 of Rule 82. Are you clear?
Okay. Mr. President, Your Honor, first I would like to clarify which parts of my speech could be heard and could be translated. I didn't observe when the mic was cut off. Okay. And then, secondly, I would like to get guidance, or if you also take into account, as far as I understand, you want to decide the request of the defense, but I think first you should decide on the request for reconsideration, taking into account the pre-trial chamber jurisprudence. And no, c'était pas ça. Okay.
Ms. Jacquin, if I may make a few points for Civil Party Group 3, I am Martin Jacquin. The defense immediately referred to Article 82, asking that the Chamber consider its application without hearing the civil parties. This is unconscionable for the civil parties because Mr. Duch's application for release is surreal in these circumstances. So we have recalled Article 82, which has been invoked for the first time before you, because this is the first time that such an application for release has been brought before a trial chamber. You can hear any party that you so wish. I think that the civil parties have the right to ask for the floor. I recall very quickly that Mr. Duch expressed remorse and regret and a request for forgiveness. And the day after that, he applies for release based on a number of arguments, of legal arguments, seeking to rely on compliance with the law in his argument. He talks about fairness, and I think that there is a minimum of recognition of the suffering of civil parties which is due here. In that light, Mr. Duch's application is unconscionable. So how can he say that he is remorseful when he asks for forgiveness and the next day asks for release? I insisted this morning that we should read out the factual analysis one by one as accepted by Mr. Duch. I think it is important for Mr. Duch to realize the gravity of the events that have brought him here today. And these facts are of particular moment to the civil parties who lost their loved ones and whose lives were destroyed. We should bear in mind that the 100 or so civil parties that I represent are brave people in light of the difficulties they have encountered since the end of the Khmer Rouge regime. These are my submissions. Thank you. Mr. Sieur.
The President, I would advise you that not to repeat the same arguments. Thanks.
Things I shall say in 2 minutes. First, during the pre-trial hearing on 18th February last, I said that as far as I was concerned, the civil parties should not take part in proceedings pertaining to the sentence. However, it is necessary and indispensable for us to respond to the arguments put forward by the defense in the issue of the provisional detention, as is the case under French law, which underpins the hybrid court before which we are today. Secondly, the civil parties are present in the proceedings on detention in the cases that will be brought before you for trial. So how can it then be possible that the civil party would have less rights in a public hearing than in hearings that arise from the investigation. It is not legally possible, and it is difficult for our clients to understand. Thirdly, in pure law, Mr. President, we have Article 82, but we also have Article 63. It is the self-same thing, but it applies to the investigation phase. And there you have reference to civil parties. Reference is made to Article 63 and 82. Therefore, it follows that these articles should be read together in light of the existence of the civil party both in investigative proceedings and at trial. That is why we should and we can, and that is why it is necessary for us to address the court on this important issue, that is the appearance in freedom of Duch, or whether he is detained.
The President, we have already informed the parties that your request will be noted, and as I informed you already that the discussion will be based on the sub-rule 2 and 3 of Rule 82, and the Chamber notes these requests and will have them discussed during lunch break. When we resume our session, then we will announce the decision regarding the matter. So it is time to break for lunch. So the Chamber would like to adjourn for the lunch break, and we resume at 1:30. The detention facility guard, please take the accused back to the detention facility and bring him back before 1:30.
The graphier, please be seated. The President. The trial chamber is now back in session. For the next proceeding, the chamber would like to ask the defense counsel whether the counsel or the accused himself has anything to say in response to the co-prosecutors regarding the release on bail, which the co-prosecutor responded this morning. Thank you.
Merci, Monsieur le Président. La défense n'a rien après les explications de ma
The explanations of yesterday. Now, is it clear? Can you hear the English? Or is it? Can you? The interpreter is asking if you can hear the English. Yes. Yes. Okay. So, the defense has nothing to add after what the co-prosecutor presented to us. The defense stands by its position, and the defense has not been convinced by the co-prosecutor, respectfully said.
The President, next, the Chamber would inform the civil parties' lawyers for their request to express their comments or opinion in response to the request made by the defense counsel for the release on bail during the entire proceedings of the trial. The trial chamber will consider this matter tomorrow in order to seek guidelines on the provisions or rules in order to clarify the right to make comments or observations by the civil parties' lawyers. And we will inform you the scheduling also on Monday, the 6th, next week. For our next proceeding, please, the lawyer.
Oui, Monsieur le Président.
Yes, Your Honor, if the chamber must deliberate on the request from the civil parties, the defense would wish to express itself on this question. We have not expressed, the chamber made a decision, the civil parties asked it to revise the decision. The defense has something to say about this request to revise this order. So I would like in a few words to express the defense's position concerning this request to review.
The President, please, the lawyer for the defense, for the accused.
Your Honor, so the defense took note of the chamber's decision indicating in compliance with pursuant to Rule 82, indicating that the civil parties did not have to be examined in the hearing for release. The civil parties are requesting the chamber not to interpret the rule, but to modify the rule. I believe that the judges always have the power to interpret, and I have been fighting for years to grant the judges the possibility of interpreting the rule of law. But here it's different. We're not asking you to interpret the rule, we're asking you to correct it on the grounds that there would be an error. So I'd like to remind you that only the plenary, the judge's plenary, has the jurisdiction to modify the rules. the chamber does not have the jurisdiction to modify the procedural rules. I do not see how we can make this request. And concerning the substance of what I'm saying, I can imagine that if the plenary assembly of the judges, in its wisdom, has written out the internal regulations in this way, it is because the plenary believed that the hearing concerning detention should not concern the civil parties. And this sends us back to this discussion that we already had here on the role of each one of the parties in the criminal proceedings. The civil parties are welcome. We welcome them to express their suffering. Of course, but anything concerning release, anything concerning the sanction is a question that depends on public order. That is to say, a question that depends on, that hangs on the responsibility of the prosecutors and on the decisions rendered by the chamber. The civil parties can make observations on detention or on release only if this has an impact on their own interests. And when I'm speaking about their interests, I'd like to remind you that we are only speaking about the reparations that the civil parties might request. A civil party such as this was explained to us the other day will never be satisfied by the sentence itself. But detention is part of the sentence. So here we are not in the domain of the civil party itself. So and I believe that when the rule was established by the judges' plenary, I believe that that was the idea. So it is true that the pretrial chamber is trying to find the way in this area in the same way as the ICC is also trying to find its way. We are, each one of us here, trying to build law, and in particular the law for the victims. Let's build this law, but let's also try to establish milestones. Who is doing what in these criminal proceedings? And I believe that the ICC, after having at first, in the Lubanga case, opened quite broadly the victims' access to the victims' access to the proceedings, the ICC rendered a second decision in which it restrained later on, because otherwise it would be impossible. Let's be realistic, and I believe that this was what the judges had in mind when they established the internal rules. In this first trial, we have 94 civil parties. In a second trial, there will be hundreds of them. Are we going to be examining hundreds of civil parties on all the topics? You can see that by trying to do things too well, we are going to hinder the idea of justice itself. So I believe that we're obliged to set milestones. and I will repeat it again to the civil parties. We will hear you. We will hear what you have to express to us, but please do not venture onto areas which are not yours. And you will be paying service to justice, but also to yourselves. Thank you.
The President, the trial chamber does not allow any civil party lawyers to express their comments. So let me move on to our next proceeding. I would like to request the co-prosecutor to read the agreement on the facts between the co-prosecutors and the defense counsel, and as well as the uncontested facts. The floor is yours.
Thank you, Mr. President. I will try to make this as clear and as brief as I can. But for the sake of clarity and remembering that in this court we have transcripts that will serve as the record, I will endeavor to put as much information in my address to you so that the record reflects accurately the information. Therefore, if you'll bear with me, and I'm addressing you today on this matter in English because this is how we set it up with the translation, even though the agreement has been done on the French version. However, the translators have copies, written copies in all three languages of what I'm about to say. But to clarify, as we've said earlier, on 31st of January of this year, we forwarded to the defense extracts of the closing order separated into separate factual allegations to seek their agreement or comments. This filing, or this document, was later filed, our document that we had sent, was filed into the record on 11 February 2009 under the quote E5/11/2-7. More precisely, ERN number 002-82-115 to 002-82-155. So this is the document that was sent to the defense and filed. We have not received an official filing in terms of their response, but this will serve as at least the recorded version, and I understand there will be an official, or there has been an official filing. So I propose to read the agreed facts or the not disputed facts. In other words, things that the defense agrees to or does not contest within this trial. And I propose to do so by referring to first sections that were duplicated from the indictment: introduction, establishment and structure of democratic Kampuchea, etc., etc. So to do so by parts, and for each fact to refer to the paragraph number of the filing that was sent to the defense. This is the number that appears in bracket at the beginning of each factual allegation, and as I said, is reflected individually in the filing of 11 February 2009. And I further propose to cover section by section so that it makes a little bit of sense in terms of the factual matters at hand. So again, with your leave, the following facts are agreed. Paragraph 3. S21 was chaired for most of its existence by Kaing Guek Eav, alias Duch. Agreed. Paragraph 5. On 5 January 1968, Duch was arrested and sentenced to 20 years imprisonment for breaching state security in relation to foreign states. Duch was set free following the coup of 18 March 1970. Agreed. Paragraph 7. From 1975 to 1979, Duch occupied posts at S21 when he was aged between 33 and 37. Agreed. Province. That is the section of the introduction. I would ask my colleague to confirm.
The President, please, the Defense Counsel.
Your Honor, I confirm in the name of the Defense Counsel the agreements that were, the points agreed that were here presented.
The President, please, the co-prosecutor continue.
On to the section titled Establishment and Structure of Democratic Kampuchea. The following facts are agreed. Paragraph 10. On 17 April 1975, the Army of the Communist Party of Kampuchea, CPK, the Kampuchea's People National Liberation Armed Forces, KPNLAF, entered Phnom Penh, and the CPK seized national power.
Pardon, un problème de matériel pour l'accusé. Si on pouvait lui donner...
An equipment problem for the accused, so if we could give him another headset.
The President, please, the co-prosecutor, you may continue.
Start again. On the section titled Establishment and Structure of Democratic Kampuchea, the following facts are agreed. Paragraph 10. On 17 April 1975, the Army of the Communist Party of Kampuchea, CPK, the Kampuchea People's National Liberation Armed Forces, KPNLAF, entered Phnom Penh, and the CPK seized national power. Agreed. Paragraph 11. With the end of the civil war against Lon Nol's Khmer Republic, the CPK's stated policy was to pass to, quote, the next phase of making socialist revolution, unquote. Agreed. Paragraph 12. During the 3 years, 8 months, and 20 days that followed, the CPK exercised effective authority over democratic Kampuchea and pursued a policy of completely disintegrating the economic and political structures of the Khmer Republic and creating a new revolutionary state power. Agreed. Paragraph 13C. The elimination of officials and supporters of the previous regime. Agreed. Paragraph 14. Many of the CPK's policies required the transformation of, quote, new people, quote, into peasants. Agreed. Paragraph 15. New people were broadly made up of evacuated city dwellers and peasants living under Lon Nol control until April 1975, as distinct from old or base people who were essentially peasants from areas under the authority, already under the authority of the CPK during the Khmer Republic period. Agreed. Paragraph 16. Politically motivated extrajudicial executions were committed at the outset by military units and continued thereafter in security centers throughout the country. Agreed. Paragraph 17. In February 1975, the CPK held a Popular National Congress of the National United Front of Kampuchea, at which it publicly announced that 7 so-called Khmer Republic super traders were to be summarily killed for treason. Agreed. Paragraph 27. Numerous persons, rightly or wrongly, linked to the Khmer Republic or its purported social class foundations were punished or summarily executed by the CPK in the days and weeks immediately following the liberation of Phnom Penh throughout the end of the regimes. The following facts are not disputed without comments as it relates to the establishment and structure of democratic Kampuchea. 13A. The forced transfer of residents of Phnom Penh and other former Khmer Republic strongholds to the countrysides. 13B. The creation of party-controlled agricultural production cooperatives where people were made to work under extremely difficult conditions to increase food production. Paragraph 18. The Congress also declared that lower-level Khmer Republic personnel would be welcomed by the revolutionary forces, quote, provided they immediately cease their service to the 7 traders and stop cooperating with them, unquote. Paragraph 19. Any such Khmer Republic personnel who did not immediately defect to the CPK were vulnerable to summary execution. Paragraph 23. All punishments specified in Article 9 of the DK Constitution were applied arbitrarily. Paragraph 24. The CPK established no appropriate facilities for captured enemy combatants or civilians, nor any mechanism to challenge the legality of their arrest, detention, or punishment. Paragraph 25. The legal structures were replaced by re-education, interrogation, and security centers where former Khmer Republic officials and supporters, as well as others accused of offenses against the CPK, were detained and executed. I would ask the defense to confirm both the agreed and not disputed factual allegations.
The defense confirms that concerning the readings that just were done concerning the historical and political context, and as we mentioned before, there's an agreement concerning a certain number of paragraphs, and other paragraphs are also not contested, as we have mentioned earlier. But maybe in order to understand your chamber a bit better, maybe we should specify that in the document that we submitted to you yesterday, there are sometimes passages in italics, and these are comments from the defense, but we will not speak about these today. And in your version, these comments are included. Thank you.
Thank you, Mr. President. The next section regards the establishment of S21. The following facts are agreed. Paragraph 29. On 15 August 1975, Duch attended a meeting with Sun Sen and In Lorne, alias Nat, from Division 703 of the ROC, at the Phnom Penh train station, for the purpose of which was to plan the establishment of S21.
Monsieur le procureur, un petit peu plus lentement, s'il vous plaît, pour la traduction.
Mr. Prosecutor, could you please go a little bit slower for the translators? Thank you.
Except, as I have mentioned to your honors, the translators have all 3 versions of the text. So I'm trying to hopefully finish before 4, but they have the text, so we will... Agreed. Paragraph 30. San Sen appointed Nat as chairman of S21 and committee secretary, with Duch as his deputy in charge of the interrogation unit. Agreed. Paragraph 31. Following the meeting, Duch brought a number of his former M13 staff to Phnom Penh to join forces with the Division 703 personnel. Agreed. Paragraph 32. S21 became fully operational in October 1975. Paragraph 34. In March 1976, Nat was transferred to the General Staff, and Duch replaced him as chairman and secretary of S21. Agreed. Paragraph 36. Duch confirmed Kim Vat, alias Hor, a former Division 703 cadre, as his deputy, responsible for the day-to-day operations of the office. Agreed. Paragraph 37. The third member of the S21 committee and head of S24 was Nun Hoi, alias Hoi Srei. Agreed. Paragraph 38. Under Duch's command, S21 was divided into distinct units, each with its own function. Agreed. Paragraph 38A. The defense section was administered by Hor and his subordinate, Phal. Agreed. Paragraph 38C. Susti was responsible for maintaining the document unit, and he reported to Duch through Hor. Agreed. Paragraph 38E. There were also a number of other units which included photography, medicine, in Duch's house. Those are the paragraphs under the heading Duch's role in arrest that I would like the defense to confirm are agreed upon.
We confirm, Your Honor, the agreement of the accused concerning the paragraphs that were just read out by the co-prosecutor.
Thank you, Mr. President. Under the heading Arrest of S-21 personnel, the following facts are agreed. Paragraph 129. S-21 personnel were arrested and either sent to Presar for re-education or detained at Tuol Sleng. Paragraph 136. Duch was the only person at S-21 who could report mistakes by S-21 personnel to the upper level, and he did so whenever a report came to him from X. Those are the agreed facts under the arrest of S-21 personnel heading that I'd like the defense to.
The floor is yours, the defense counsel, say the President.
Nous confirmons la...
We confirm the agreement of the accused concerning the paragraphs that were read concerning the arrest of the S-21 personnel.
As the co-prosecutor, you can continue, say the President.
Thank you, Mr. President. Under the heading Conditions of Detention at Tuol Sleng, the following facts are agreed. Paragraph 138. Prisoners entered S-21 on nearly a daily basis. Agreed. Paragraph 140. Prisoners were registered and lists of their names were compiled by S-21 cadre X. Agreed. Paragraph 141. Prisoners were required to provide information regarding their biographies, which was then summarized. Agreed. Paragraph 142. Photographs were taken of newly arrived prisoners, which generally included a number and sometimes their name and date of arrest. These photos were taken on instruction from Son Sen to aid in the recapture of any escapees. Agreed. Paragraph 143. Persons who were arrested and imprisoned at S-21 were usually not informed of the reason for their arrest. Agreed. Paragraph 144. Prisoners at S-21 were kept in restraints nearly 24 hours a day. Agreed. Paragraph 145. The S-21 detention facility had both small individual cells and larger collective cells where prisoners were chained side by side with their legs shackled. Agreed. Paragraph 146. Prisoners who were shackled could not stand up. Agreed. Paragraph 147. Female prisoners generally remained unshackled unless they created problems. Agreed. Paragraph 148. Prisoners at S-21 were kept under permanent guard. Guards from both inside and outside the detention facilities were instructed to be vigilant in preventing escape attempts. Agreed. Paragraph 152. Prisoners were not permitted to exercise or leave their cells. Agreed. Paragraph 159. S-21 detainees only received starvation rations of food. As a result, many suffered substantial weight loss and physical deterioration, and some died. Agreed. Paragraph 160. Starvation of prisoners was a deliberate policy of the CPK. Paragraph 161. S-21 guards and important prisoners received better nutrition than ordinary prisoners. Agreed. Paragraph 162. Many detainees at S-21 suffered from illnesses or injuries. Agreed. Paragraph 166. Medicine was in very short supply at S-21. Even when available, the medicine was locally produced by unskilled workers. Agreed. Paragraph 167. S-21 medics understood that the purpose of medical treatment for prisoners was to keep them alive long enough that their interrogations could be completed. Agreed. Paragraph 168. S-21 personnel performed medical experimentations on prisoners. Agreed. Paragraph 168A. Research for poisons was carried out upon the orders of the Central Committee provided to Duch by Nuon Chea. Agreed. Paragraph 168B. Autopsies were practiced on living persons. Agreed. Paragraph 168C. Blood was taken from prisoners. Agreed. Paragraph 168D. New medicines were tested on prisoners. Agreed. Paragraph 169. The conditions at S-21 severely impaired the physical and psychological health of many of the detainees and, in many instances, caused their death. Agreed. Paragraph 171. Some prisoners at S-21 attempted to commit suicide. The following facts, under the heading Conditions of Detention at Tuol Sleng, are not contested. Paragraph 139. Prisoners were generally blindfolded and handcuffed when brought inside S-21. Paragraph 150.
Mon collègue, nous avons eu un petit problème.
We had a slight translation problem, and it was translated that the following paragraphs were the object of an agreement, but they are just simply not disputed. It's just a small point that I would like to specify for the purposes of translation. So, I apologize. You may continue.
The President, the trial chamber may take a 20 minutes break because I can see that the co-prosecutor is tired already. So please take a 20 minutes break.
Grafia, please be seated. The President, the trial chamber is now back in session. May the co-prosecutor read the statement, read the
document again.
And I am feeling much better. Thank you. I would like first to correct an omission on my part. In the agreed facts of under the heading Conditions of Detention at Tuol Sleng, paragraph 160 is admitted. Starvation of prisoners was a deliberate policy of the CPK. Thank you. I continue. Under the heading of Conditions of Detention at Tuol Sleng, the following facts are not disputed. Paragraph 139. Prisoners were generally blindfolded and handcuffed when brought inside S-21. Paragraph 150. Prisoners at S-21 were not permitted to speak to each other or to the guards. Paragraph 151. When prisoners first arrive at S-21, they were often stripped of their clothes, leaving just their underwear. Paragraph 153. The majority of S-21 detainees were provided no bedding and slept on the concrete floor. A few privileged prisoners were provided old mats or mattresses to sleep on. Paragraph 154. Many detainees were badly bitten by mosquitoes. Paragraph 156. There were no washing facilities at S-21. Prisoners remained shackled when bathed. Bathing consisted of guards spraying the cell with a hose from the doorway. The primary purpose of this hosing was to clean the cells, not the prisoners. Paragraph 157. Prisoners were not permitted to leave their cells to use the toilet and were forced to urinate in jerry cans and defecate in ammunition boxes. Paragraph 158. Prisoners were typically fed twice a day with poor quality gruel. Paragraph 163. Medical services at S-21 were provided by a team of 3 to 5 medics who had not studied medicine. Some of those medics were children, and they worked without the supervision of medical doctors. Paragraph 164. Some prisoners received intravenous fluids in the evening and were found dead the following morning. Paragraph 165. In need of urgent medical attention were left unattended or given insufficient treatment. Paragraph 170. During 1 month, 8 or 9 prisoners died in X cell. X's cell. Those are the relevant facts agreed to or not contested under the heading Conditions of Detention at Tuol Sleng that I would request the defense to confirm.
So, the President, please, the Counsel for Defense, the floor is yours.
Merci.
Mr. Ho, thank you. The defense agrees to the previously agreed matters and the undisputed matters in regard to the paragraphs that have just been read out concerning the detention conditions in Tuol Sleng. Thank you.
The President, the co-prosecutor may continue.
Mr. President. Under the heading Detention Conditions at Pre-SAR, the following facts are not contested. Paragraph 172. At S-24, people were sent for re-education through punitive hard labor, also referred to as tempering. Paragraph 174. Persons sent to S-24 were strictly guarded both at work and at night. Paragraph 175. Persons sent to Presar were separated into 3 levels, one for light tempering, a second intermediate level, and a third level for the most serious cases. Paragraph 176. Persons considered to be level 3 were kept shackled at night and were not permitted to live in ordinary houses. Paragraph 177. Detainees were provided 2 meals a day, one at noon and one in the evening. With few exceptions, the food provided to prisoners at Presar was insufficient. Persons in level 3 received lower rations than others. Paragraph 179. Detainees at S24, including women and children, were forced to work in the rice fields, fish, grow vegetables, transplant rice, build paddy dikes, dig canals, and carry soil to make ponds. Paragraph 180. Detainees worked day and night, 7 days a week, and were not permitted to rest during working hours. A typical working day at Presar started at dawn, between 4 and 7 a.m., and finished between 10 p.m. and 12 midnight, with 2 hours to rest and eat. Paragraph 181. Work was carried out under the supervision of guards who required detainees to be efficient and berated them if they worked slowly. Paragraph 182. When detainees were sick or late, or when their work was considered unsatisfactory, they were beaten and insulted. Paragraph 183. Prisoners were also punished for, quote, sexual misconduct, illnesses, and stealing, unquote. Paragraph 184. Inmate X was beaten 2 or 3 times. Paragraph 185. On some occasions, guards at S24 punished detainees by starvation. Paragraph 186. Prisoners feared that if they did not work as hard as they could, they would end up dead. Paragraph 187. Regular re-education meetings were held at Presar, at which detainees were instructed to work quickly and efficiently, given political training and indoctrination, and required to partake in self-criticism sessions where they were forced to concede their faults and those of others. Paragraph 188. Disappearances of prisoners during the night were common, and the persons taken away never returned. Paragraph 189. Some Presar detainees, most likely people from level 3, were transferred to Duch for execution. Paragraph 190. At least 571 persons, including both S24 personnel and inmates, were transferred from S24 to Tuol Sleng. Those are the uncontested facts under the heading Detention Conditions at Presar, to which I would request the defense to confirm.
The President, please, the defense lawyer response.
Mr. Ho, thank you, Mr. President. The defense confirms that it does not dispute any of the paragraphs read by the co-prosecutor as far as the detention conditions in Presar are concerned.
The President, the co-prosecutor may continue.
Mr. President. Under the heading Interrogation, the following facts are agreed to. Paragraph 191. The majority of prisoners detained at S21 were systematically interrogated. Paragraph 192. Interrogations were conducted by S-21 personnel who were organized by Duch in various teams. Paragraph 193. Agreed. Paragraph 193. Interrogators did not choose the prisoners they would question, but rather were assigned those prisoners. Agreed. Paragraph 195. In interrogation rooms, prisoners would typically have their legs shackled to a table, after which their handcuffs were removed to allow questioning and confession writing. Agreed. Paragraph 196. Interrogators questioned prisoners on their biographies and on the activities which led to their arrest. Agreed. Paragraph 197. Not all interrogations led to a written confession. Agreed. Paragraph 199. There were no established limits on the number of times a prisoner could be interrogated or how long an interrogation could last. Agreed. Paragraph 199A. Interrogations only ended when the confession of the prisoners was considered completed. Agreed. Paragraph 199B. Prisoners could be interrogated repeatedly and forced to redraft their confessions numerous times. Agreed. Paragraph 201. Duch introduced 3 methods of interrogation at S-21. The, quote, cold, hot, and chewing methods. Agreed. Paragraph 201A. Correction. The cold method was interrogation through the use of propaganda without relying on torture or insults. The following factual allegation is not contested under the heading interrogation. Paragraph 198. Interrogations took place every day from 7 to 11 a.m., from 2 to 5 p.m., and then from 7 to 11 p.m. Those are the factual allegations agreed to or not contested under the heading interrogation, to which I'd like the defense to confirm.
The President, the Defense Counsel may respond.
Mr. Hu, the defense confirms that agreement has been reached or there is no dispute with regard to the paragraphs that the co-prosecutor has just read concerning the questioning in S-21.
The President, the co-prosecutor may continue.
Thank you, Mr. President. Under the heading, systematic use of torture during interrogations, the following facts are agreed. Paragraph 204. 3 notebooks belonging to S-21 interrogation, the, quote, statistical list of Security Office S-21, politics, ideology, and organization, unquote. The, quote, the X notebook, unquote, attributed to X, and, quote, the Y notebook, quote, recorded instructions received regarding interrogation and torture at S-21. Agreed. Paragraph 204A. The statistical list included political and interrogation instructions taught to interrogators, such as to, quote, break prisoner by propaganda or break him by torture, unquote, and, quote, if Ankar instructs not to beat, absolutely do not beat. If the party orders us to beat, then we beat with mastery, beat them to talk, not to die, to escape, not to become so weak and feeble that they fall ill and we lose them, unquote. Agreed. Paragraph 204B. The instructions and political ideologies contained in the X notebook and in the statistical list accurately reflected Duch's teachings and instructions at S-21 and were primarily his, quote, thoughts, unquote. Agreed. Paragraph 208. The purpose of interrogation at S21 was to obtain a complete answer which included the prisoner's alleged crimes and identified other purported enemies of the regime. Agreed. Paragraph 209. With respect to Vietnamese prisoners, the purpose behind the interrogation was to obtain confessions showing, quote, that Vietnam had invaded Cambodia with a view to integrating it into an Indo-Chinese federation, unquote. Agreed. Paragraph 211. Unlike Cambodians, the interrogation of Vietnamese prisoners were often tape recorded, and some of their confessions were then broadcast on the radio for propaganda purposes. The following facts, under the heading Systematic Use of Torture During Interrogation, are not contested. Paragraph 205. Physical consequences of torture, i.e. lacerations, bleeding, bruises, unconsciousness, and missing finger or toenails, were visible on the prisoners detained at S21 and noticed by S21 personnel. Paragraph 206. Most of the prisoners detained at S21, quote, had injuries and their faces were swollen and there were burns around their ears from electrical shocks, unquote. Paragraph 207. Certain guards at S21 also personally saw or heard the torture being carried out there. Paragraph 214. One day, in the painter's room, Duch ordered X to exchange blows with a sculptor, Y, by hitting each other with a rubber hose. Under the heading Systematic Use of Torture During Interrogation, those are the paragraphs agreed to are not contested that I would like the defense to confirm.
President, the defense counsel may respond.
Mr. Ahu, thank you, Mr. President.
Mr. Petit, the added problem is that you are reading a non-redacted version of this document, and I'm wondering if instead of asking you to use the pseudonyms that have been assigned, you simply use an initial, because the identity of the particular person is not important to the agreed facts at this stage. Would that be acceptable also to Maître Roux? He says yes.
So we'll take that yes and run with it. I apologize. I will use creatively initials. Not that I'm confirming or infirming that any witnesses so far have been mentioned, but any names of any individuals will therefore be referred to as initials, or with initials rather. If someone could remind me where I was. Right. Agreed. Paragraph 38E. There were also a number of other units which included photography, medicine, cooking, and logistics. Agreed. Paragraph 39. Duch ran S21 along hierarchical lines and established reporting systems at all levels to ensure that his orders were carried out immediately and precisely. Agreed. Paragraph 43. The original S21 complex was located in Phnom Penh in Bong Kaing Kang 3 subdistrict, Chamkar Mon district. The detention and interrogation facilities were originally located in a block of houses on the corner of streets 163 and 360. Agreed. Paragraph 44. In late November 1975, S21 moved to the National Police Headquarters on Street 51, Rue Pasteur, near Central Market, Smart May. Agreed. Paragraph 45. In January 1976, S21 moved back to its original location. Agreed. Paragraph 46. In April 1976, upon Duch's decision, S21 moved to the premises of the Phnéa Yat Lycée, a high school located between Street 113, 131, 120, and 350, now the site of the Tuol Sleng Genocide Museum, where it operated until 6th January 1979. Agreed. Paragraph 47. The central building of S21, referred to as Building E, was used to receive, register, and photograph prisoners, and a room was devoted to creating paintings and sculptures that glorified the regime. Agreed. Paragraph 48. 4 other buildings at S21, buildings A, B, C, and D, were used for detention. Agreed. Paragraph 48A. Buildings B, C, and D held the general prisoner population in a mixture of large mass detention cells and small brick or wooden individual detention cells. Agreed. Paragraph 48B. Building A, together with the block of houses located south of the former lycée, called the Special Prison, housed important prisoners. Agreed. Paragraph 49. The former school and the Special Prison were surrounded by fences and protected on the interior and exterior by armed guards and were the most secure and secret part of the S21 complex. Agreed. Paragraph 51. Initially, prisoners were executed and buried in and around the S21 complex. Agreed. Paragraph 52. At some time between 1976 and mid-1977, partly in order to avoid the risk of epidemic, Duch decided to relocate the execution site to Chung Aik, located approximately 15 kilometers southwest of Phnom Penh in Kandal province. Agreed. Paragraph 53. The Chung Aik execution site consisted of a wooden house where prisoners were held until just before their execution, and a large area that consisted of pits for executions. Agreed. Paragraph 54. Even after Chung Aik became the main killing sites, certain executions and burials still took place at or near the S21 complex. Agreed. Paragraph 55. S24 was part of S21. Agreed. Paragraph 56. S24 was tasked with reforming and re-educating combatants and farming rice to supply Office S21 and its branches. Agreed. Paragraph 58. The primary role of S21 was to implement, quote, the party political line regarding the enemy, unquote, according to which prisoners, quote, absolutely had to be smashed, unquote. The following facts are not disputed and regard the same section, the establishment and structure of democratic Kampuchea. Paragraph 13A. The forced transfer of residents of Phnom Penh and other former Khmer Republic strongholds to the countryside. Paragraph 13B. The creation of party-controlled agricultural production cooperatives where people were made to work under extremely difficult conditions to increase food production. Paragraph 18. The Congress also declared that lower-level Khmer Republic personnel would be welcome. I'm sorry. This bodes well. I apologize to the court. I am rereading a section that I have already read. And if nobody else has noticed, I apologize for that. The following facts are not contested. Under the heading Establishment of S21, paragraph 40, Duch was feared by everyone at S21. Paragraph 50, many other buildings in the surrounding neighborhood were also part of S21, serving as interrogation houses, execution sites and mass graves, mess halls, a medical center, houses for the staff, various offices and houses for Duch, and a house for the reception of prisoners. These buildings were all situated within a second outer perimeter that was also protected by armed guards. Paragraph 57. S24 was located outside of Phnom Penh, near the execution site of Choing Ek, in the area of Wat Dol, in the Dang Cao district of Kandal province. The main structures and activities at S24 extended from the Presar prison to Chek village, though the total area of S24 was larger. Those are the agreed or not disputed facts under the heading Establishment of S21 that I would ask the defense to confirm.
Mr. Hu. Yes, Mr. President, Your Honors. The defense confirms that it is in agreement and does not dispute the paragraphs that have just been read out by the prosecutor, the co-prosecutor, pertaining to the section on the establishment of S21.
The President may the co-prosecutor continue.
Under the heading, the policy of smashing enemies, the following facts are agreed. Paragraph 59. The term smash was used and widely understood at the relevant time to mean kill. Agreed. Paragraph 64. In practice, a subcommittee of the Central Committee, known as the Standing Committee, acted as the highest and most authoritative unit in DK. Agreed. Paragraph 65. A Standing Committee decision from 9 October 1975 gave Pol Pot general responsibility over the military and Son Sen responsibility for the general staff and security. Agreed. Paragraph 68. Duch primarily dealt directly with Son Sen and Nguyen Chia, both of whom he believed to be acting on behalf of the Standing Committee. Agreed. Paragraph 71. From late 1975 and into 1976, S21 was significantly involved in the imprisonment, re-education, torture, and execution of persons linked to the ousted Khmer Republic regime. Agreed. Paragraph 72. As of 1976, the CPK had largely eliminated private property, officials of the former regime, religions, teachers, and what it considered to be the exploiting classes. Agreed. Paragraph 73. By March 1976, the CPK had clarified the authority to execute at different levels within the regime and increasingly sent members of the revolutionary ranks to S21. Agreed. Paragraph 74. A CPK Central Committee document dated 30 March 1976 decided that in order that, quote, there is a framework in absolute implementation of our revolution, unquote, and, quote, to strengthen our socialist democracy, unquote, the right to, quote, decide on smashing within and outside the ranks, unquote, was bestowed as follows. Quote, if in the base framework to be decided by the Zone Standing Committee, surrounding the Center Office to be decided by the Central Office Committee, independent sectors to be decided by the Standing Committee, the Center Military to be decided by the General Staff, unquote. Agreed. Paragraph 75. The 30 March 1976 Central Committee document marked the beginning of internal purges within the CPK. Before that time, it was mainly officials of the old regime who were smashed. From that point on, executions at S21 were mainly internal purges of persons from within the party and the military. Agreed. Paragraph 75. Duch's role as chairman of S21 was to focus the office on smashing purported traitors within the ranks of the revolution itself. Agreed. Paragraph 78. Initially, it was only used for important prisoners. Correction. Agreed. Paragraph 78. Initially, S21 was only used for important prisoners or those from Phnom Penh, as well as members of the Central Committee. Low-ranking combatants were only sent to S21 if arrested in Phnom Penh. High-ranking enemies inside the party, state, military, or security apparatuses implicated by confessions obtained from other prisoners were generally sent to S21. Agreed. Paragraph 79. When a superior was arrested, such as X, member of the Central Committee, his or her subordinates would in turn often be sent to S21. Agreed. Paragraph 80. The policy of smashing enemies almost always extended to their families, including children. Agreed. Paragraph 82. By January 1979, S21 had detained persons from nearly every zone, every ministry, and every military unit in the nation. Agreed. Paragraph 83. S21's role also included executing those persons in the revolutionary ranks who were accused of being influenced by or under the control of Vietnam due to their former or contemporaneous associations with the Vietnamese Communist Party. Agreed. Paragraph 84. As the armed conflict with Vietnam intensified, the numbers of Vietnamese civilians and soldiers arrested and sent to S21 also increased. The following facts under the heading "The Policy of Smashing Enemies" are not contested. Paragraph 62. The CPK governed Democratic Kampuchea primarily through DK state organization, CPK administrative bodies, and the RAC. Paragraph 63. The 1976 Constitution of Democratic Kampuchea and the party's own statutes gave the CPK Central Committee wide powers, including the ability to formulate party-wide policy and the authority to issue orders to subordinate zones and sectors. Paragraph 70. Although the policy of smashing enemies remained in force throughout the DK period, the definition of those perceived to be enemies of the CPK evolved and broadened over the period as a result of domestic developments and the international armed conflict between Cambodia and Vietnam. The above stated facts, as agreed or not disputed under the policy of smashing enemies, I would like the defense to confirm.
Merci, Monsieur. La défense.
Mr. Hu, thank you, Mr. President. The defense confirms its agreement or the absence of dispute in regard to the paragraphs that have been read out by the prosecutor. Thank you.
The co-prosecutor, you can continue, said the President.
Dissemination of policy at S21. The following facts are agreed. Paragraph 85A. Duch and other S21 cadre attended general political education and agricultural production planning meetings convened under the auspices of the Center General Staff. Paragraph 85B. Duch and other S21 cadre attended training session convened by Son Sen to discuss the need to purge and smash enemies. Paragraph 85C. The policy of extrajudicial execution was widely disseminated by Duch throughout S21 at annual meetings of the entire unit as well as at smaller meetings of its various subunits. Duch and other CPK members and Youth League members at S21 were also made aware of the role of their office in implementing CPK policies through the party journals Revolutionary Flag and Revolutionary Youth. Agreed. Paragraph 88. Allegations of treason to which S21 prisoners had been compelled to confess were presented as fact in the Revolutionary Flag and Revolutionary Youth publications and alluded to in other official DK propaganda. Agreed. Paragraph 89. Alleged traitors such as Chan Chakre, Men San, alias Ya, Suos Neu, alias Chuk, and Koi Tun were repeatedly referred to by name. Agreed. Paragraph 90. Extracts from tape-recorded S21 confessions or written text were played or read out at meetings outside of S21 to justify the actions of the regimes. Agreed. Paragraph 91. From the time Duch became S21 chairman, all specific instructions to and from S21 regarding security matters were conveyed exclusively through him. Those are the agreed fact under the heading Dissemination of Policy at S21 that I would request the defense to confirm.
The floor is your defense counsel, say the President.
Mr. Aho. Thank you, Mr. President. The defense confirms its agreement, perhaps with one minor clarification at paragraph 85C. Our first version, which we received, is somewhat different from what has been read out. I do not think that this will occasion any great difficulty. I do not think this will raise any great difficulty. In the first version, we have agreement, and the policy of extrajudicial killings was widespread in S21, whereas it is said that the extrajudicial execution policy pertaining to detainees was widespread by Duch in S21. I do not think that it raises any great problem. We are in agreement. May I be allowed to verify this with my team members?
Merci, Monsieur le Président.
Mr. Hu. Thank you, Mr. President. We agree with the reading that you've just provided of paragraph 85C and of course with the others.
The co-prosecutor, you take the floor.
And just to clarify, I have right here at my disposal the exact filing that was sent to the defense, and it is exactly what I read today, so I'm not sure what happened, maybe in the translation. But what I read was what was given to the defense. The following facts under the heading, the use of S-21 confessions, are agreed. Paragraph 93. The role of S-21 was not to determine whether detainees were traitors, as their guilt was already considered established by the fact that they had been arrested and sent to S-21. Agreed. Paragraph 94. In addition to executing prisoners condemned in advance as traitors, an overriding purpose of S-21 was to extract confessions from prisoners in order to uncover further networks of possible traitors. Agreed. Paragraph 95. S-21 confessions typically took the form of political autobiographies by the prisoners in which they were compelled to denounce themselves and others as traitors serving the intelligence agencies of foreign powers considered to be enemies of the Cambodian Revolution, such as the CIA, KGB, and the Vietnamese Communist Party. Agreed. Paragraph 96. S-21 confessions contained detailed descriptions not simply of alleged treacherous activities, but also of the structure and operation of all levels of the party and of all administrative units. Agreed. Paragraph 97. The operations of S-21 were, quote, not compatible with the existence of tribunals and procedural safeguards, unquote. Agreed. Paragraph 98A. Regardless of whether they contained false or fabricated assertions, S-21 confessions were used to decide upon arrests of those denounced as enemy agents and often led to the arrest of many others implicated as traitors. Agreed. Paragraph 98B. Normally, implication in one confession was not sufficient for a person to be arrested. It had to occur several times. Agreed. Paragraph 100. Duch meticulously read, analyzed, annotated, and summarized the majority of S-21 confessions for his superiors. Those are the following facts as agreed to under the heading the use of S-21 confessions that I would request the defense to confirm.
The President, the floor is your, Mr. Francois Rouge, say the President.
La défense confirme en effet.
Thank you, says Mr. Hu. The defense confirms that the accused agrees with the paragraphs that have been read out by the co-prosecutor.
Thank you, Mr. President. Under the heading Composition of the Detainee Population, the following facts are agreed. Paragraph 103. The prisoners were predominantly Cambodian. Agreed. Paragraph 104E. Relatives of DK Cadre were also arrested and detained at S-21. Agreed. Paragraph 104G. S-24 staff were also sent to Tuol Sleng. Agreed. Paragraph 105. Former Khmer Republic soldiers and officials were held as prisoners at S-21. Agreed. Paragraph 106. A number of Cambodian minority groups, including Cham, were detained at S-21. Agreed. Paragraph 108. The largest group of foreigners detained at S21 was Vietnamese, which group included hundreds of Vietnamese civilians and soldiers. Agreed. Paragraph 109. Prisoners at S24, Prey-Sar, included men, women, and children, and consisted of two main categories: persons whose relatives were considered suspect, and subordinates of arrested cadre. There were also combatants from various units and personnel from numerous ministries and offices around Phnom Penh, together with members of their families. Agreed. Paragraph 110. Several hundred people worked at Prey-Sar at S24 at any given time. The following facts under the heading Composition of the Detainee Population are not contested. Paragraph 104A. 5,000 prisoners came from DK government offices. Paragraph 104B. Over 4,500 prisoners came from DK military units. Paragraph 104C. These prisoners came from virtually every office and unit in the country and from all existing zones and autonomous sectors. Paragraph 104F. Approximately 200 former S21 staff became prisoners at Tuol Sleng. Paragraph 107. Foreign nationals were also imprisoned at S21, including Vietnamese, Thais, Laotians, Indians, and, quote, Westerners, unquote. Paragraph 108A. At least 400 Vietnamese were detained at S21, of which approximately 150 were recorded as prisoners of war and at least 100 were civilians. Paragraph 108B. The first recorded arrest at S21 of someone described as Vietnamese was on 7 February 1976. Paragraph 108C. The number of Vietnamese detained at S21 increased as the conflict with Vietnam escalated. Those are the agreed and not contested facts under the heading Composition of the Detainee Population that I would request the defense to confirm.
The defense, you take the floor, say the President.
Merci, Monsieur.
Mr. Hu, just one clarification to make it easy for people who do not have access to the document to understand. I am referring to paragraph 104. It should be read in whole. The first part was the largest group. I refer to the detainees in S21. The largest group was composed of cadres of Democratic Cambodia. We agree. And then there is point A, B, and C, not contested, and we added there were more than 5,000 civil servants and employees of the DK administration. I refer to people in S21. So we have the prisoners came from all the offices and autonomous sectors of the country. So I just want to clarify this for people listening to us. I just want to clarify what we agreed with and what we did not dispute. So we just agree with the reading that was provided by the co-prosecutor.
The prosecutor, you can continue, say the President.
Under the heading Arrest, thank you, Mr. President. Under the heading Arrest and Transfer to S21, the following facts are agreed. Paragraph 111. For the arrest of members of the Central Committee, the decision had to be made by the Standing Committee. Agreed. Paragraph 112. For others, Duch's superior, Nguyen Chea, called the head of the relevant unit for discussion and a joint decision on arrest. Agreed. Paragraph 113. For people coming from other regions who were to be sent to S21, the decision to arrest was made by the Standing Committee, which contacted the relevant zones, sectors, or districts in order to remove persons implicated by confessions. Agreed. Paragraph 115A. On these occasions, Duch provided the names of the persons to be arrested, where the arrest would take place, and how many forces were required to effect the arrest and transfer to S21. Agreed. Paragraph 117. Duch was informed on the arrival I apologize. I'll start again. Agreed. Paragraph 117. Duch was informed of the arrival of Vietnamese POWs by means of a list transmitted by either Nguyen Chea or X, his direct subordinate and former chief bodyguard of X. Under the heading Arrest and Transfer to S21, the following facts are not contested. Paragraph 116. Vietnamese POWs were generally arrested in or near the main conflict zone on the border with Vietnam and transported to S21 by the unit that arrested them. Those are the facts under the heading Arrest and Transfer to S21 that are agreed or not contested, which I'd like the defense to confirm.
The President, the Defense Counsel, you take the floor.
Mr. Ho, the defense confirms the accused's agreement with regard to the paragraphs that have been read out by the prosecutor.
The prosecutor, you can continue, say the President.
Under the heading Duch's role in arrests, the following facts are agreed. Agreed. Paragraph 120. On 16 September 1976, Duch attended a military meeting of Divisions 290 and 170, also attended by Son Sen and X, the purpose of which was to plan arrests. This meeting was called because there were an exceptional number of arrests to be carried out within a single unit. Agreed. Paragraph 122. Decisions concerning arrest were kept secret in order to avoid leaks and ensure that there was no possibility of resistance, especially when large numbers of persons were to be arrested from one place. Subterfuge was also used to keep those units off guard. In such cases, Duch would assign X to talk with the person in charge of the unit to calm the personnel and facilitate orderly arrest. Agreed. Paragraph 123. The decision to arrest people was often based on S21 confessions which implicated them as traitors. Paragraph 127.
Interrogation. On behalf of the accused, the defense confirms its agreement or the absence of dispute. I should just like to provide some clarification. You will observe, for example, that we have agreed with the co-prosecutors not to read paragraph 203, although it is indicated that Duch was in agreement. But this is the sort of paragraph where we wanted the entire closing order, or the paragraph as it appears in the closing order, to be copied in full. But, so you will see that Duch is in agreement, but he wants the paragraph to appear as it does in the closing order. Perhaps I might add something. Paragraph 214, which you read, already appears in the personal participation of Duch in torture sessions. It already appears there.
The President, the co-prosecutor may continue.
Thank you, Mr. President. Under the heading Duch's personal participation in torture, the following facts are agreed. Paragraph 215A. One of the persons who received such orders from Duch was Comrade X, who, quote, liked to use torture very much. That fact is agreed. Agreed. Paragraph 216B. Duch prohibited interrogators from letting prisoners die during torture. Agreed. Paragraph 217. Duch received orders from his superiors, including Nat and Son Sen, to have certain S-21 prisoners tortured and implemented those orders. Agreed. Paragraph 219. The method of torture most commonly used at S-21 was beating with a stick because other methods wasted time. Agreed. Paragraph 220. If a detainee did not properly confess, the severity of torture was increased. A confession was improper if it was insufficiently detailed or failed to name other traitors. Paragraph 221 is agreed. Duch knew about the practice of S-21 of puncturing or removing finger and toenails. Agreed. Paragraph 223. Duch was aware that cold water and fans were a method of torture used at S-21 and did not react to that practice. Paragraph 226 is agreed. Another practice that took place at S-21 was forcing detainees to pay homage to images of dogs. Duch was aware of this practice and had encouraged it at an interrogator's training session on May 28, 1978. I'd like to correct. The paragraphs I've just read from 215A to 226 should have been correctly identified as being under the heading of torture techniques. And those facts, as I've read them under paragraph 215A to 226, are agreed. And under that same heading, torture techniques, the following facts are not contested. Paragraph 224. Another method of torture used at S-21 during interrogation was to remove the clothes of a prisoner and use electrical equipment to shock the prisoner's genitals or ears. Paragraph 228. S-21 prisoner X was repeatedly beaten on the back with a piece of wood and had his toenails pulled out from both of his feet. He received electrical shocks on his earlobes and on the third day of torture fell unconscious twice. X was subjected to this treatment for 12 days and 12 nights. Paragraph 229. S-21 prisoner Y was shown various torture equipment in his interrogation room and asked to choose which implements would be used against him. He was beaten on the back with a whip, a rattan stick, and electrical cables while handcuffed and forced to lie down on the ground. His back was cut and bleeding all over the floor. He was also electrocuted. Y was tortured twice a day for a period of 2 weeks. Under the heading and torture techniques. These are the facts which have been agreed to or not contested, which I'd like the defense to confirm.
The President, the Defense Counsel may respond.
The Defense Counsel confirms the agreement or the non-dispute of the paragraphs that the co-prosecutor has just read.
The President, the co-prosecutor may continue.
Thank you, Mr. President. Under the heading Pre-Sar, the following facts are not disputed, not contested. Paragraph 233. In one room at S24, men and women were interrogated using electrocution. Paragraph 234. People who were sent to Pre-Sar would return with their heads shaved and their skin flayed from the application of electrical shocks, beatings, and whippings during interrogation. Those are the facts, the factual allegations, which are not contested under the heading Pre-Sar, which I'd like the defense to confirm.
The Defense Counsel may respond, says the President.
Thank you. The Defense Counsel confirms that there is no dispute concerning the paragraphs that have just been read on Pre-Sar. Thank you.
The President, the co-prosecutor may continue.
President, under the heading Authority over Executions, the following factual allegations are agreed. Paragraph 239. Duch and X gave the orders to carry out executions within the S21 complex. Agreed. Paragraph 243. Prisoners at S21 were typically killed shortly after completing their confessions. The following factual allegation under the heading Authority over Executions is not contested. Paragraph 235. Over 12,380 detainees were executed at S21. Those are the factual allegations under Authority over Execution that are agreed to or not contested, which I'd require the defense to confirm.
The President, the Defense Counsel may respond.
Thank you. The Defense Counsel confirms that there is no dispute or that there is agreement concerning the paragraphs that have just been read and concerning the authority to order executions. Thank you.
The President, the co-prosecutor may continue.
Thank you, Mr. President. Under the heading Executions at Chung Aik, the following facts are agreed. Paragraph 247. Duch went to Chung Aik in 1977 at the request of Son Sen. Paragraph 251A is agreed. Prisoners were blindfolded and had their arms tied behind them. Agreed. Paragraph 253. On 4 separate occasions, Duch was ordered by Son Sen and Nguyen Chea to send the majority of prisoners detained at S21 to Chung Aik to be executed. The purpose of these executions was to make room for large following mass arrest. Agreed. Paragraph 254. Numerous mass executions which occurred in which Duch received and conveyed orders to execute without interrogation. Agreed. Paragraph 254A. On one prisoner's list, Duch handwrote, quote, "To the attention of Uncle Peng, kill them all, 30 May 1978, unquote. Paragraph 254B is agreed. On another prisoners list containing the names of 29 prisoners, Duch wrote, quote, interrogate 4 persons, kill the rest, unquote. Paragraph 254C is agreed. In December 1978, about 300 prisoners from the East Zone who had allegedly rebelled were sent directly to Chung Ike and executed. Agreed. Paragraph 254D. On 2nd or 3rd January 1979, Nonchea ordered Duch to smash all the prisoners at S21. Approximately 200 persons, who were Cambodian nationals and Vietnamese soldiers, were then transported to Chung Ike and killed. Under the heading Executions at Chung Ike, the following facts are not contested. Paragraph 245. Many thousands of persons, including men, women, and children, were executed and buried at Chung Ike. Paragraph 248. Prisoners were transported to Chung Ike in trucks 2 to 3 times a month. Paragraph 248A. The vehicles in which X was transported to Chung Ike each contained 30 to 40 prisoners. Paragraph 248B. Prisoners were told that they were being transferred to a new home so that they would not scream during transport. Paragraph 248C. Prisoners were handcuffed and blindfolded in the trucks. Paragraph 248D. During transportation, 2 guards were positioned in the rear of the truck so that prisoners could not jump from the vehicles. Paragraph 249. 3 to 4 guards were regularly stationed at Chung Ike. When joined by the transport guards, there were as many as 10 guards present for executions. Paragraph 250. There were 3 execution teams: the special unit, X team, X's team, and Y's team. Paragraph 251C. Prisoners were taken outside by the guards one at a time and told they were being transferred to a different house. Paragraph 251D. X stood outside and recorded the names of prisoners before taking them to the pits to be killed. Paragraph 251E. Prisoners were killed using steel clubs, cart axles, and water pipes to hit the base of their necks. Paragraph 251F. Prisoners were then kicked into the pits where their handcuffs were removed. Paragraph 251H. After the executions were complete, the guards covered the pits. Paragraph 252. Several large-scale executions took place at Chung Ike. Under the heading Executions at Chung Ike, these are the facts agreed to or not contested, which I'd like the defense to confirm.
The President, the Defense Counsel may respond.
Your Honor, the defense confirms that the accused has given his agreement or has not disputed the facts that the co-prosecutor has just read to us.
Il semblerait qu'il y ait eu une traduction.
Problem in the translation, and that in Khmer it was indicated apparently that there was no dispute to paragraph 251 section G. We should probably check the translation that was done, because 251G, you haven't read it, but apparently in the Khmer translation it was read by indicated that it was not disputed. 251G. So for the needs of the retranscriptions, I would like to specify that paragraph 251G is not the object of an agreement. Just to let you know, for the needs of the transcriptions, and you haven't read it in fact, but it seems that in the translation it was, however, included.
The President, the co-prosecutor, please.
Thank you, Mr. President. Finally, under the heading Execution at Tuol Sleng, the following facts are agreed. Paragraph 255 is agreed. While Chung Ek was used as the main killing site, certain important persons, such as Khoi Thun, Vorn Vet, Hoc, Nat, and foreigners, continued to be executed within S21's grounds or nearby. Agreed. Paragraph 257. Duch, pursuant to a request of his superior... I'll start again. Agreed. Paragraph 257. Duch, pursuant to a request of his superiors, had pictures taken of important prisoners after they had been executed, including Lee Fel, Von Vet, and Hoc. The purpose of these pictures was to provide evidence that certain prisoners had not been released or escaped. Agreed is paragraph 258. In 1978, 4 foreigners... Agreed. Paragraph 262. 4 combatants from a military unit designated Y08, who had been arrested and detained at S21, were killed by S21 interrogator X using a bayonet. Their bodies were left on beds in S21 and discovered when Vietnamese soldiers arrived at the complex. The following facts, under the heading Executions at Tuol Sleng, are not contested. Paragraph 256. Mass graves were present within and around the S21 complex. Paragraph 259b. X was ordered by Y on 2 occasions to write lists of those detainees who had their blood drawn. Paragraph 259d. S21 prisoners who were subjected to this process had 4 to 5 bags of blood extracted from them, which left them unconscious. Paragraph 259e. The prisoners would die sometime after the extraction of their blood, and a vehicle would then transport their bodies to Chung Ike for disposal. Paragraph 260. Children of S21 prisoners were taken away from their parents, killed within the S21 compound, and buried north of the prison. Those are the factual allegations under the heading Executions at Tuol Sleng, which are agreed to, are not contested, and which I would like the defense to confirm.
The President, the Defense Counsel may respond.
Thank you, Mr. President. The defense confirms that Duch acknowledges the facts that have been read out concerning the executions, whether it be for the points which he agrees or the points that he does not dispute. And maybe another specification, however, the accused requested that we use the term S21 and not the term "twelve slang" that he does not recognize because it's a term that was only given after the fact. In what it concerns him, he was the director of S-21. 12 slang is a word that was given after the arrival of the Vietnamese troops.
The President, the co-prosecutor, the floor is yours.
Just to make sure that the record is accurate, I apparently left out 3 agreed facts, which are, or to mention simply that these facts were agreed, which are listed under paragraph 201A, 211, and 262. Those 3 facts are agreed. I already read the facts. I simply forgot to say agreed. And this, Mr. President, Your Honors, complete the reading into the record of the factual allegations which are agreed to, are not contested by the Crown, by the prosecution, and the defense. And I thank you for your indulgence and your patience.
The President, the proceeding of today's hearing is going to adjourn for today's session. The hearing will resume on the 6th from 9 a.m. The Chamber orders the detention facility officers to take the accused back to the detention facility and bring him back to the courtroom on the 6th of April before 9 a.m. The participants and civil parties and the public who wish to attend, please arrive before 9 a.m. on that day.